Self-test. What are the civil rights obligations of state administering agencies, or SAAs? This self-test provides a series of scenarios with related questions to help you see whether you understand the responsibilities that SAAs have in monitoring the compliance of subrecipients with federal civil rights laws. First, let us provide some background. With funding from the Office of Justice Programs, Central State Department of Public Safety, or DPS, made 15 subawards to police departments in the state, including the Eagleton Police Department, which has over 500 employees and received $150,000 under the Juvenile Justice and Delinquency Prevention Act.
Here's the first scenario. Ethel Fielding filed a complaint with the Eagleton Police Department alleging that when she reported a stolen bicycle to the Eagleton Police Department, an officer refused to take the report and ridiculed her national origin and her use of a hearing aid. What are the Department of Public Safety's responsibilities concerning this complaint? Take time to consider how you would answer this question. Here's the answer. The Department of Public Safety should have already monitored the Eagleton Police Department to ensure that at a minimum, the agency had a written policy for addressing discrimination complaints from beneficiaries, stating that it would refer complaints either to the state administering agency, which in this case is the Department of Public Safety, or to the Office for Civil Rights. Law enforcement agencies are a particular class of subrecipients. Unlike other subrecipients, the Office for Civil Rights ordinarily expects law enforcement agencies to have more developed in-house complaint procedures for dealing with discrimination complaints from members of the public. The Eagleton Police Department would have this obligation regardless of the size of its workforce or the amount of federal assistance it receives. The Department of Public Safety could either deal with the Eagleton Police Department's apparent lack of complaint procedures on its own, or it could refer the matter to the Office for Civil Rights. In addition, in this case, one of Ms. Fielding's complaints was that she was mistreated based on her hearing disability, being ridiculed for wearing a hearing aid. One might interpret her complaint as including an allegation of disability discrimination. The Eagleton Police Department, which has more than 50 employees and which received a grant of more than $25,000 from the Justice Department, had an obligation under Section 504 of the Rehabilitation Act of 1973 to have a civil rights coordinator and a grievance process. In this instance, the police department appears to have had neither, which would indicate that it is not in compliance with federal law.
In the second scenario, Ms. Fielding initially contacted the Department of Public Safety to complain about the alleged discriminatory conduct of the Eagleton Police Department. She spoke to Mr. Summit, a Department of Public Safety program manager, who told her that the Department of Public Safety is not responsible for the conduct of the Eagleton Police Department. Is this correct? The answer is no. The information Mr. Summit provided to Ms. Fielding was not correct. As the SAA, the Department of Public Safety has an obligation to assist Ms. Fielding with her discrimination complaint. The Department of Public Safety should have a written policy for addressing discrimination complaints that it receives not only from its own employees and beneficiaries, but also from the employees and beneficiaries of subrecipients. In this instance, Ms. Fielding, as a beneficiary of services from one of the Department of Public Safety's subrecipients, has the right to file a complaint with the Department of Public Safety. The Department of Public Safety should have written grievance procedures that would provide for it to investigate the complaint, refer the complaint to another agency, or refer the complaint to the Office for Civil Rights. The written complaint procedures should include information about the designated complaint coordinator and the process for investigating and resolving the complaint. Once Mr. Summit learned about Ms. Fielding's complaint, he should have accepted it and referred the matter to the Department of Public Safety's complaint coordinator.
Here's the third scenario. Last month, the U.S. District Court issued a finding that the Eagleton Police Department discriminated on the basis of national origin by failing to promote Sergeant Aquila to the rank of lieutenant. What should the Department of Public Safety or the Eagleton Police Department do with this finding? Recipients and subrecipients of federal financial assistance subject to the non-discrimination provisions of the Safe Streets Act that receive an adverse finding of discrimination based on race, color, national origin, sex, or religion from a federal or state court or from a federal or state administrative agency, which is the result of a due process hearing, have an obligation to send a copy of the adverse finding to the Office for Civil Rights. The Eagleton Police Department is a recipient of federal financial assistance under the Juvenile Justice and Delinquency Prevention Act, which is subject to the non-discrimination provisions of the Safe Streets Act. Because the police department received an adverse finding of discrimination from a federal court, it has an obligation to submit a copy of the finding to the Office for Civil Rights. Although the police department has its own independent responsibility to submit a copy of the finding to the Office for Civil Rights, the Department of Public Safety is also responsible for ensuring that the police department, as one of its subrecipients, is complying with this civil rights obligation. The Department of Public Safety should monitor its subrecipients to determine if there are any discrimination proceedings in which the subrecipients are a named party, and then ensure that the subrecipients submit adverse findings to the Office for Civil Rights for review.
The Office for Civil Rights notes that it is a good practice for SAAs to gather adverse findings of discrimination from their subrecipients and then forward them to the Office for Civil Rights. In this way, the SAA's monitoring practice not only ensures that the subrecipients are in compliance with the law, but also that the SAA is as well. This concludes the self-test on the training segment, What are the Civil Rights Obligations of State Administering Agencies?